It's said that if love is grand, well, divorce, it's 100 grand. So if you think your marriage is heading towards a divorce, this is a must-see video as I interview one of the most decorated divorce attorneys in California and ask her what you need to know about divorce. Elizabeth Yang is an expert on family law and focuses on mediation, collaborative, and child custody cases. She's been awarded the Super Lawyer Rising Star Award, thereby ranking her as the top 2.5% of the best attorneys in California. So I gotta say, she's a badass. Now this video is longer than usual, so if you need to skip, there are chapters at the bottom to help. And one last item. I normally don't ask for this at the beginning of any video, but to keep the flow and not interrupt, if watching from Facebook, as nearly 70% of you are, press on the 3 horizontal dots, then press open on YouTube and the video should continue. That way you can see the chapters, comment on any additional questions you have, press like of course, and subscribe so you could see when I upload a new video. And last, join our closed Facebook group for men. The link is in the comment section underneath. So, let's begin. Gosh, that was a lot of instructions. Thank you very much, Elizabeth, for joining us in this episode of The Renaissance Men. Your background is really fascinating. I introduced you already, but if you could just give us a little background into how you got into becoming a divorce attorney.
Sure. So my name is Elizabeth Yang, and my law practice is called the Law Mediation Offices of Elizabeth Yang. I started my career as an IP attorney due to my electrical engineering and computer science background, and initially only specialized in patents, trademarks, copyrights, because it was more relevant with my engineering background. And then it wasn't until I went through my own 4-year divorce starting in 2010 that I expanded into family law.
And then you were telling me earlier that it was just a real, it was a real complicated divorce, correct? Or something to that effect?
It was a 4-year long divorce. I switched 5 different lawyers to represent me, and it was probably one of the most complicated divorces. Compared with all the ones that I've currently handled, I still see mine as one of the more complicated ones.
And then what happened?
Well, after 4 years, after countless hearings, trials, restraining orders, child custody battles, child support battles, we ultimately still couldn't finalize the divorce. Or attorneys were not able to help us complete the process. And finally, we went through a settlement. We mediated and came to an agreement in order to finally finish the case. So I use my experience to encourage everyone else out there who's currently going through the process to do mediation early on and not wait until after 4 years of spending so much of attorney fees to then do settlement.
Yeah, I know my first divorce was capitalized over a 6-figure price tag. And I think only the children are the ones that really end up paying for it, because that could be money that's going to them. People let their emotions get ahead of them. You kind of brought me to the next scenario. Suppose there's like a husband and he wants to mediate, but the spouse doesn't. Is there anything that you do as a mediation attorney to get them, that you could coach them into how to talk to the spouse?
If they're not represented by counsel, then I can talk to both parties and usually let them both agree to come in and meet with me and go over the issues and do my best to settle their issues, negotiate on behalf of both parties. If they are represented by counsel, then it really depends on who their attorney is. There's a lot of other attorneys out there who practice collaborative divorce like myself, and they're willing to work with me and do like a 4-way mediation to help the parties settle their issues. But I've also dealt with very difficult opposing counsel whose main purpose is to fight, which may not be in the best interest of their clients, but they want to fight, and sometimes they just won't even consider any settlement proposals. Fortunately for all parties, if there's any court hearing scheduled, the courts require the parties to go through a mediation session before seeing a judge. So even if a party is completely unreasonable and won't come into my office to mediate, or won't schedule a mediation session, they still have to go through the mediation session through the court system.
Okay, gotcha. So have you been busy with the whole COVID-19 situation, or?
Yeah, this year has been especially busy, and I guess it's expected. Everybody's stuck at home, seeing each other for 24 hours a day. Plus, you add in some kids who aren't in school and are taking classes on Zoom. If they don't get along, it could be a pretty, ugly lifestyle. They could hate being at home. And so we've been getting calls in the day, in the evenings, on the weekends from parties wanting to get advice on how to file for divorce.
Do you have any idea how much busier your practice is since the beginning of this?
I would say almost twice as busy.
Okay. Didn't you mentioned earlier that, sorry about that.
Oh, it's okay. We've had to hire new attorneys in order to keep up with the busy workload and also the phone calls coming in. And we've also had to hire additional support staff as well to handle all the new divorce cases. And not just divorce cases, there's also new domestic violence cases. A lot of parties are wanting to file for restraining orders. On the more positive end, there are more people getting married too. It's like you either make a marriage choice, a divorce choice, or you have a baby. A lot of people are getting pregnant too. So we've been doing a lot of prenups at this time too.
Are you? Okay. That's so if I'm going to interview for attorneys, what are some things to look for?
Well, number one, have the necessary experience in order to successfully handle their case. A lot of different times, different fact patterns come up. And so an attorney who is well-versed in family law and has dealt with a multitude of different cases will be the one who's competent. The second aspect is empathy, right? They've got to be sympathetic to what the client is going through and understand that this is not just any other civil case, right? There's emotions involved. There are relationships at stake. There are children at stake. It's not just something where it's only about money. So they got to really be empathetic to the client. And for myself, I would recommend someone who's gone through the process, because it's really hard to empathize with someone who's going through a divorce if you've never been through.
Would you say that a lot of your clients try to use you as a, how would I put this? Use you as a psychologist or a mental health or a health professional in that sense?
Oh, yeah, absolutely. My husband is in HR, and it's so funny because me and him always joke about that. Ultimately, we do the same thing. We're like therapists listening to our clients' problems, and a lot of times clients come to us. I mean, they want the legal advice, but at the same time, they also want someone to hear them out. So we do a lot of listening to our clients and being there for them in their times of need.
Yeah, that could only imagine. I always said that if I could do it all over again, I would be a divorce attorney for that reason, actually, because it could just get out of control. It's a Cold War, basically, what's going on.
Absolutely. Yeah. And communication, being understanding is super important during this process.
So are there any questions that you would recommend a person would go asking an attorney, like when they're during the interview process?
Yeah, some of the questions I would recommend asking is, how long have you been practicing as a family law attorney? You would tell the attorney your specific fact pattern and see if they've dealt with cases similar to those facts before. Also, you would ask how busy they are. You want someone who is responsive to your emails. When emotions are high, clients want responses quickly. even 24 hours sometimes is too long for them to wait. So at our firm, we're fast, because I remember when I was emailing my attorney and I wanted an answer, I'd be like just watching my email, refreshing, waiting for my attorney to respond. If I called them, I would want them to be available, because otherwise I couldn't do anything else. I would just be like sitting there waiting for an answer. So I know how my clients feel like, and that's why being responsive is one of our biggest values. We are really quick about responding to an email or a phone call.
You mentioned the empathy factor. Is that something that they could work against an attorney, or have you ever gotten attached to a case, or is that common?
When you say attached to a case, you mean like, not being able to sleep because we're worried about the client's case?
Because
like
you're
that?
pissed at what happened, that you don't think it's fair and you want to take justice in there.
Oh, yeah, absolutely. And it's very few cases, because in my opinion, I think the best attorneys are the ones who don't get emotionally involved. Like the clients are already so emotional. When the attorneys also get emotional, then the case is definitely not going to settle. So I will have my own opinions about cases too, and sometimes very strong opinions, but I try not to let my feelings get in the middle of getting a reasonable result for my clients.
Okay. And another question I have is, I always hear about filings. It's file first, file first. What's your philosophy? Is it better if the guy files first?
There's really not a big difference regarding who files first. Whether or not you're the petitioner or the respondent, it's really just a naming scheme in terms of, how the courts figure out who's the petitioner, who's the respondent, just a title. But the only difference I usually tell my clients is, if you're the petitioner, you have control, because you can dictate when the case is filed and when the respondent gets served. Whereas in the beginning of the case, the respondent, all they can do is wait to be served. So I've had cases where the petitioner promised they were going to file this week, and then 2-3 weeks would go by and the respondent still hadn't been served yet. So that uncertainty of when they were going to get served would drive them crazy. And so that's like one advantage of control that the petitioner has.
It's refreshing to hear you say that, because I often hear that it's better if the guy files first in our case, because they're seen as the defendant, because the petitioner is closer to the jury, and so forth. But I personally don't feel that it's necessary. I mean, I on both of them, I have 2 divorces, by the way. Congratulations. But on both of them, I was the respondent, and it didn't bother me at all.
Yeah. And, in family law trials, it's usually a bench trial, which only involves the judge. No jury is involved. So there's no difference where the parties are seated in front of the judge. Usually it's very equal. They're all seated the same distance from the judge, and there's no jury on either side.
So suppose you have a situation where a couple, they're separated, right? But they're living together. And a lot of people say, stay living together until the divorce is final. But I say that's a real challenge emotionally. I mean, that's one of the toughest times. You're in limbo. What would you say about that? And is there anything that can be done?
Yeah. So in a divorce, there's an in-spouse and an out-spouse. The in-spouse is the one that remains living in the family home, and the out-spouse is the one that moves out. So usually the out-spouse is at a disadvantage, because when they move out, they've got to find a new place to rent, or if they want to buy, they can buy, but usually they're renting, and that's an additional expense on top of their mortgage. If the in-spouse is not paying for their mortgage, then the out-spouse still has to be responsible during the time, before a court hearing is set, because they don't want the house to foreclose. And then additionally, if there's are children involved, the courts usually don't want the children's lifestyle to change too much. They like maintaining the status quo. So they would want the children to stay in the original family residence that they're most familiar with, and to take them out and put them in a new environment is something that will work for visitations, but not for primary custody. So a lot of times the in-spouse would get primary custody of the children.
So here's this problem: was your divorce took 5 years? Mine, my first one was my children, took 2 years. That's a real challenge to be going through that. Is there anything that can be done in the meantime to expedite it?
Well, the best case scenario is if the parties can reach some kind of informal agreement on custody, on paying expenses, and then have it signed in writing before the outspouse even moves out. That way, when the outspouse moves out, it's very clear, if there's a 50-50 arrangement, then they can find a place that also has enough space for the kids, like maybe 2 or 3 bedrooms instead of 1 bedroom, and be able to buy clothes and shoes and furniture for the children so that the children can be comfortable being in both places. And then there won't be that battle, between the 2 parents after they move out. And there won't be that uncertainty either. So that's, again, where mediation comes in, so that the parties can settle and create terms that work for their lives, rather than have a judge, who is a stranger to their home, come in and make orders for them to follow.
But what about you're in a challenging situation where they're just not getting along, and there's no chance for mediation here? Is there anything that the male, because the guy usually moves out, is there anything that the guy can do to make sure that he continues seeing his children for at least during that time that they're getting the divorce? And as far as the mortgage is concerned, any chance that they could get back rent, seen as back rent for that when they sell the house?
Yeah, so there's something called pendente lite orders. So the spouse that's moving out can ask the court to issue pendente lite court orders, which are like temporary orders for child custody while they're working things out and pending a trial date. So these temporary orders would give both parties direction as to who the child's going to be living with on what days, and how much maybe temporary support in the meantime. If the in-spouse is in the house and, there's no additional rent expenses for that person, then that could affect the temporary support as well. So judges will order temporary terms that the parties can follow while they're settling their case and working on their case.
So I'm coming to you and I'm saying, look, I need to move out, and it's just a mess over here. Let's do the pendente lite order.
Pendente lite, yeah, it's Latin.
Pendente, okay, got it. Pendente lite order.
Lite.
Yeah, that. So I come to you. How long does it take for that to happen?
Well, if it's something really urgent, we can file an ex parte motion to see if the judge will grant emergency orders to allow the party to move out. If the judge doesn't think that it's an emergency, then we can also, in the ex parte application, request for a motion to shorten time for a hearing to get these pendente lite orders. So if the judge thinks that, it's better for the parties to have temporary orders, then he or she could set a closer hearing to get those orders set, and instead of waiting 2-3 months out.
Oh, okay. So we're talking weeks?
It could be weeks. Yeah, a few weeks.
Okay. Now, in the meantime, let's suppose this isn't going, there are no orders. I moved out. Can the father pick up their children without concern of being charged with kidnapping or anything to that extent?
Yeah, without a court order in place, there's no kidnapping or violation of an order. Like if the father comes back and tries to pick up the children, let's say worst case scenario, the mom calls the police and says he's trying to kidnap the kids. The police is going to first ask, show us your court order for custody. And if both parties don't have a court order, then the police will say, well, there's nothing we can do because there's no order for us to enforce. You guys need to go to court and get a custody order before we can do anything. So without a court order, it's like free for all. The parents just have to, do their best to communicate and co-parent.
And that was one of the challenges that I had because I was very passive during my first divorce. It was a 5-month span where my children didn't spend time with me, and that was the worst. I mean, that was one of the loneliest times. So what I was told is you might piss off the judge if you do take the children without their mother's consent. So that was something that stopped me from doing it.
Oh, no, you wouldn't piss off the judge. Like the judge wants the kids to have access to both mom and dad. So if you took the kids and didn't return them, that might, piss off the judge because then you're not co-parenting well. But if you just took the kids and then brought them back and then like took turns, that's perfectly normal.
What are some common mistakes that you see people make, or men in particular, when they are getting divorced?
So one of the mixed mistakes I've seen is that when people file for divorce, they don't close their joint accounts. They leave their joint accounts open, or they leave joint credit cards open. And then all of a sudden, one party goes and spends a lot of money on the credit cards, and then the other party is liable for that debt. Or one party goes and shuts down the bank account and takes all the money, and then the second party ends up having no access to money in the short term. So whenever I talk with my clients, I tell them, you guys need to close all joint accounts. If there's any bank accounts, just split the money and put it into your respective individual accounts and cancel all your joint credit cards.
I have a story about that. During my first divorce, I never changed my passwords, and my ex-wife, she had all that information. So any communication that I had with my attorney, she knew about it. And I thought she had the best, most amazing attorney because I had no idea that there was a breach there. So every time there was communication, she was between me and my attorney and she was 2 steps ahead, and she knew what was going on. So
yeah, definitely change all your passwords too. You don't want your ex to have access to all your communications.
Yeah, I didn't find that out until my second divorce, where she told me.
Oh man!
So now we co-parent really well. Now we co-parent well. She's we get along well and everything. So, suppose a judge gives full custody to one of the parents. How long before the other parent can try to get some kind of custody and get the ball rolling?
So custody can be modified regularly, so usually courts will make an order and then it'll be in place for 3 months or so. And then the court will make a step-up order if, both parties, if one party wants 50-50, then there will be a step-up plan. So every 3 months, approximately, give or take, the custody will continue increasing as long as they've been co-parenting well, they've been utilizing their time, not being late and canceling visitations, then they can keep moving up until they get 50-50.
Okay. Wow. So every 3 months.
Approximately. Yeah. Some judges, think 3 months is too short and might make it longer. But I would say on average, 3 months for a step-up plan is good.
So do you need to hire an attorney for that? What if it's been years and you don't want to go through an attorney on this? Is there any way to do the paperwork and get it started?
So you don't need an attorney for any family court proceedings, right? It's of course better because it's a very complicated proceeding. And so if you don't have someone professional to navigate you through it, it might be very challenging and you might make a lot of mistakes along the way. But if you want to do it yourself, it's definitely a possibility. And the courts have a self-help center that's free to all litigants to go in and get help with the documents.
What do you see the natural history of you had a bad divorce, it's done and over with? Do you ever follow up or hear from your old clients how they're doing with their ex-spouse and co-parenting and so forth?
Typically, if they're doing well, then I don't hear from them. It's only if they continue to have issues or if new problems arise, then I will hear from them. And then they're usually contacting me to help them file new modification documents, or another restraining order, something like that. So in my field, no news is good news.
Okay. So, are restraining orders something that's going to, are they easy to get? Because it's my understanding they're pretty easy to get. And if they do have one against the spouse, does that affect at all the decisions of the judge?
So there's a lot of different types of restraining orders. There's what's called an emergency restraining order. That's where if you call the police to the home or to wherever you are when the incident happens and the police makes an arrest, then they will grant the victim an emergency protective order that lasts for 7 days. During those 7 days before it expires, that victim can go to the courts and then apply for what's called a temporary restraining order. Right? Even without the emergency order, they can still apply for a temporary restraining order. The temporary restraining order is a lot easier to get because you don't need a hearing to prove the facts. The other party does not need to be notified, and the other party won't have a chance to speak up for themselves. But the temporary restraining order usually only lasts for about 30 to 45 days, and then a hearing is set for determination on whether to convert that temporary restraining order to a permanent restraining order. So for the permanent restraining order hearing, both parties need to be present, tell their story, and then the judge will decide whether or not to grant a permanent restraining order that can last anywhere from 6 months to 5 years.
Wow.
And for your second part of your question, if there is a restraining order in place, it does become a factor in determining support, spousal support. When the courts grant one party spousal support, they can choose not to grant an abuser any support. So
you have a situation where, what if you see an abuser? I've heard of this in a lot of Facebook support groups where one spouse is recording the other one. Is that admissible in court?
So usually recordings are only admissible if they're done with the person's permission. If you're secretly recording, it can be objected to.
So have you seen any instances where it is, or it has been?
I haven't seen any instances where secret recordings were presented in court and allowed by the judge. Okay. Usually they're objected to.
Okay. Well,
yeah, but if there's like cameras in the house and both parties know about the cameras, then those camera footages can come into court in restraining order hearings.
I focus a lot on grieving men and right around the time where the wife wants the separation. Often the writing is on the wall. Is there anything that you would say to somebody that you wish you could say to somebody 6 months before they see you about finances or anything to take care of this before they actually go to an attorney?
But in terms of preparing for a divorce, so when a divorce is filed, something called ATROS comes into play, ATROS. They're automatic temporary restraining orders that tie up all the property and assets. So after the divorce, you cannot sell property, you cannot gift property or transfer property without the other person's permission. So a lot of times, if there's something that belongs to you or to a parent, you want to return it to them before you file for divorce. Because otherwise, after you file for divorce, it's stuck in the litigation and you can't transfer it.
Thank you very much. Very insightful. Is there anything that you'd like to to say that I perhaps did not bring up during this interview?
Yeah, in terms of child custody, I tell my clients that if you guys have children together, there's really no benefit to fighting the other parent long term, because even though the divorce is going to be over and you guys will not be married anymore, you guys will always be connected at the hip because you have the children. Later on when your children get older, if you guys don't get along, the children will get smart and play you against each other. They'll say, oh, if you're not going to buy this for me, I'm going to go to the other parent's house. They'll buy it for me. Or like, I don't have to listen to you. I can go live with the other parent. So that's like the last thing you want to hear, right? So you want to be on the same page as the other parent, even though you guys are not married, just for the sake of making parenting and disciplining your children easier. And going forward for the long term, you guys are going to be going to graduations together, weddings together. You're going to be grandparents together. So you forever will be family. And it's best to just make the best of it instead of fighting for 18 years.
Wonderful. That's beautiful because, and I could say, like, I don't know how your situation is, but like my ex and I, we co-parent well, even though we were at war with each other during the divorce. It was not pretty. And hopefully, I don't know how yours is, but.
Yeah, I went from a 4-year divorce with 2 restraining orders. We each had restraining orders against each other, spending $500,000 in attorney fees, to now being very good friends, being able to co-parent with each other and have play dates together, celebrate the children's birthdays together. So if my case was possible to completely do a 180, then, any case is possible.
Words of wisdom. Thank you very much. Thank you, Elizabeth. And you are located in four areas in Southern California, correct?
Yes. Our main office is in Monterey Park, but we also have offices in Irvine, in downtown Los Angeles, and also in Beverly Hills.
Okay. And I'll give away your address your website is?
Our website is yanglawoffices.com.
yanglawoffices.com. Okay. Thank you very much, Elizabeth, and for your time and for your insight, and I appreciate it.
You're welcome. It was a pleasure to be on here. Thank you for inviting me.
Certainly.
I'ma wake up, do damage. Drawing number 7, Z sport. Working all night.